The IRS believes that one of the largest areas of noncompliance in tax law is the misclassification of independent contractors and employees. The consensus is that this misclassification problem is costing the federal government billions of dollars, and something must be done. Not only in tax law, but also in wage and hour law, misclassifying employees as independent contractors can have implications on benefits as well as their wages. For example, a day worker may receive wages on commission, classified as an independent contractor, and not receive any sort of workplace protection. This can cause problems because in some cases that worker should be considered an employee, for he is completely dependent upon the employer financially, but because he is classified as an independent contractor, the day worker will not be paid the state's minimum wage or overtime benefits. There seems to be a lot of gray area on this issue, so how does a court differentiate between an independent contractor and an employee? Well, before 2010, the protocol for courts when deciding whether someone was an employee or an independent contractor was to apply the right to control test. Under this test, the court would decide how much control the employer had over how the job was done, and ultimately whether the worker was an independent contractor or an employee. The employer doesn't actually have to utilize the control, it just has to have the ability to control how the job is done if it chooses to do so. In the end, if the employer is found to control the employee, then the individual is entitled to employee benefits. But if the employer is not found to control the employee, then the court will move to the nature of business test. This says that if the work performed is the same as the occupation of the employer, then that individual would be considered an employee. In 2010, the Washington State Court of Appeals in Anfinson v. FedEx added yet another test. The court ruled that a worker is an employee under the wage and hour law not by the right to control test or the nature of business test, but by the economic realities test. The appellate court affirmed that the previous tests were flawed and did not apply to this case. This test classifies a worker as an employee if the worker is financially dependent upon the employer, therefore broadening the scope of the definition of employee. The case that decided this was Anfinson v. FedEx, where two truck drivers were misclassified as independent contractors, filed a class action lawsuit, and ultimately awarded overtime wages and uniform expenses. The court made their decision by also considering the Department of Labor and Industries guidelines, which include the worker's potential to succeed or fail based on the quality of the training, the worker's personal investment in the materials, the skill required to do the job, and how important the job is to the business as a whole. After this court decision, the requirements have ultimately made it easier for a worker to be considered an employee, which is extremely important for businesses to consider. The reason that this was so important is now many more workers who are currently classified as independent contractors may now be considered as employees and receive minimum wage benefits and overtime benefits, which could potentially cost employers a lot of money. Fortunately, this decision also closed a loophole that was allowing employers to misclassify their workers as independent contractors in order to reduce their own expenses and liability. I'm currently in a situation that this law is applicable to. I joined a fraternity at the University of Washington and was on the recruitment team. We were paid on commission per new member. We had a quota of 16 new members and had about 7 months to recruit them, and if we failed to meet our quota within that time period, we'd be paid nothing. Unfortunately, we were not able to make our quota by our deadline, so we were not compensated. But under this wage and hour law court decision, I believe we should be classified as employees, not independent contractors, because we were financially dependent upon our employer, who was the fraternity house. We were trained and told how to do our job. We were given supplies in the form of a budget, and participating as a member of the recruitment team was an essential part to the house's success. Using the decision in the Anfinson v. FedEx as precedent and the Department of Labor and Industries guidelines, I believe we would be considered employees and entitled to minimum wage benefits and overtime benefits for our hours worked. But in the end, this new change of policy will raise more questions than answers, and those will be left for the future courts to decide. Thank you.